Good afternoon and welcome to the Health, Government and Operations Committee. This is Tuesday, April 1st, right? So be careful what questions you're going to be asked. We do have quite a few bills. We're going to get started. I know the Senate is still on the floor, right? So we have their chief of staff and staff that are going to be testifying as well. For those that are home watching us, a lot of these bills we have already heard. Okay, if we rush through them, it doesn't mean we're disrespectful. It's just that we had them in committee and we have people that came forward and against it and we study them. So this is the second time around as well. I'm going to, if your bill is in the same posture, all I need to hear is that it's in the same posture. Okay, and welcome to HGO. So let's get going. Who is here for Senator Kagan? Okay. How about Senator Zucker? Will you be so kind and come up? Who was here first? Who came first today? Okay, let's go.
Good afternoon, Chair, Vice Chair, and distinguished members of the HGO Committee. For the record, I'm Georgie Jones here on behalf of Senator Zucker to testify on Senate Bill 764. Senate Bill 7, both bills have passed their respective chambers unanimously. We ask for a favorable report.
Okay. Is this your first time here?
It's been a minute, yeah.
Yeah? Okay.
It's been a while.
Do we have questions for her?
This is what I remembered from last time.
Thank you so much. Let her know you did great, okay? Have a blessed day. This actually concludes the bill hearing on Senate Bill 764. Who came second? Who came second? All right.
Good afternoon, Madam Chair.
Good afternoon.
I'm Stephen Reswick with the Maryland Department of Natural Resources. Our posture remains the same.
All right, so you're supporting the bill?
Yes, ma'am.
Oh, but actually, hold on a minute. This is Senate Bill 764, and you're testifying in support, right?
Yes, ma'am, that's correct.
All right, and your position supporting it is still the same?
Yes, ma'am.
Wonderful. Any questions? All right, thank you so much.
Thank you.
All right, this concludes really. You have a question? Okay, so hold on a minute, sir. This is still Senator Zucker. Yeah. So this concludes the bill hearing for real on Senate Bill 764. Again, I'm not fooling, for real. All right, let's move on to Senate Bill 854, Senator Lewis. And this is Health Occupation License Direct Entry Midwives Revisions. Good afternoon. Tell us your name.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Andrew Burgoyne. I'm Chief of Staff for Senator Karen Lewis Young. I'm here to testify in favor of SB 854. It's an update to the License Direct Entry Midwives Practice Act from 2015. This bill comes to you in the same posture as the cross-file sponsored by Delegate Cullison, and has passed the Senate unanimously.
Okay, are there any questions? All right, seeing none, thank you for testifying and give the senator my love. This concludes this bill hearing. Now we're going to go to Senate Bill 456. Anyone here for Senate Bill 456? Senators McKay and Augustine, Dental Services Qualification for Medical Dent Care Program. This is jointly assigned with appropriations. Good afternoon.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee. My name is Sam Lawrence. I'm Senator Mike McKay's Chief of Staff, and this is also in the exact posture as House Bill 265, which passed out of this committee with amendments. Ours had the same amendments, which passed out of the Senate 43-0, and yours crossed over into the Senate 122-13.
A pro. All right. Any questions for him? Seeing none, this concludes the bill hearing on Senate Bill 456. Thank you very much.
Thank you.
Anyone here for Senate Bill 491? Senator Guile. Okay, how about Senate Bill 555? Anyone here for 555? Public Information Act denials pending litigation.
Good afternoon.
Good afternoon. Thanks, Madam Chair. Patrick Hughes. I'm with the Attorney General's office.
This bill is not in the same posture as what you saw before. The House cross-file version did not move in your committee. The Senate moved an amended version that changes the bill in a couple of important respects. So as a reminder, this is a bill that would create a new exemption in the PIA that would allow but not require a custodian to withhold records created for purposes of pending or reasonably anticipated litigation until the litigation is over. And the two amendments that were made on the Senate side that I wanted to discuss here with you today. First is the bill as amended would apply only to records created for purposes of pending or reasonably anticipated litigation, as opposed to the version you saw, which was broader and would apply to any records pertaining to such litigation. So this means that, as amended, the bill would not preclude requesters from seeking underlying documents that pre-existed the potential for litigation, but might become relevant evidence in the litigation. This is focused just on sensitive records that were created for the very purposes of the litigation. And that is similar to an exemption that exists in at least 7 other states, and also similar in spirit to a exception in Maryland's Open Meetings Act that allows public bodies to close meetings to consult with staff, consultants, or other individuals about pending or potential litigation. So that's one change on the Senate side. The other change is that there was an amendment that now defines what reasonably anticipated litigation is. I know there were some concerns about the vagueness of that term. And so, as you'll see in the bill, the amended language defines it as a situation where there's concrete evidence that litigation is expected to occur based on the current facts and circumstances at the time of the request. So as amended, this legislation serves 2 primary purposes. First, it would protect the integrity of the adversarial judicial system by preventing opposing litigants from using the PIA to obtain sensitive records created by an agency for the very purpose of the litigation. In the adversarial system, most litigants can obtain that type of information, if at all, only through discovery. But government litigants are put at an unfair disadvantage in litigation if public record laws can be used to obtain that sort of information from private parties, but not vice versa. And then second purpose, the legislation would help prevent opposing parties or their allies from using the PIA as a tool to disrupt the government entity's litigation efforts, including the affirmative litigation OAG brings to vindicate the public interest and the rights of Marylanders. As explained in our written testimony, these aren't just theoretical concerns. Some PI requests even seem to be designed specifically to disrupt the work of the attorneys working on the litigation. A good example of that would be the many PI requests OAG received during the first Trump administration from groups seemingly allied with the federal administration that were seeking documents created for the purposes of the litigation OAG was engaged in with the federal government. And the proposed exemption would serve this purpose in part by clarifying the ability of custodians to withhold, sensitive documents created because of the litigation. Although many such records are already protected by existing privileges like work product, attorney work product, an exception like this would clarify the presumptive protection applies to all the records in these categories without having to go document by document and line by line to apply some of the technical existing legal doctrines, which in turn makes it easier to respond to requests like this and lessens the disruption of requests seeking documents created because of the litigation. So in sum, OAG urges a favorable report on Senate Bill 555 as amended, which again is in a different posture than what you had before you. Happy to answer any questions.
I see, and thank you for being with us. We appreciate it. I see some questions. First, I'm going to start with Delegate Chisholm.
Sure.
Thank you, Madam Chair.
You're welcome.
And thank you, Patrick. I understand the current litigation. Obviously, it's pretty straightforward. So, but when I'm reading the amendment in this section, reasonably anticipated litigation means a situation where there is concrete evidence that litigation is expected to occur based on current facts and current circumstances. Can you expand on that? Is that like the AG goes out and gives a press conference and says we plan to bring litigation against the federal government for X, Y, and Z? Because I know you guys did this to further define, but then I'm like, well, because it was vague, and then I'm like, well, to me, this is vague as well, because what's concrete evidence? Can you give me an example?
Sure, I can give you a couple of examples, I think. So one example would be in a defensive litigation posture if someone files a claim under the Maryland Tort Claims Act with the Treasurer's Office, which is a preliminary step to often bring tort suits against the government. There are non-lawyers in the state treasurer's office who deal with those claims and look into them and make judgments about how meritorious or not they might be. And so that would be an example of reasonably anticipated litigation, but also one where the attorney work product doctrine, for instance, might not apply to those kinds of discussions because it's not the lawyers sitting down and deciding how are we going to respond to this potential litigation. It's non-lawyers at the state agency putting together views about the merits of that litigation. So that would be one example of a situation of reasonably anticipated litigation. Another be sort of like what you described. If there are conversations between the Maryland Attorney General and other attorneys general around the country about bringing a potential legal action, there's going to be a common interest agreement. There's going to be evidence of the discussions of potentially bringing that litigation, and those discussions are sensitive, just like if the litigation had already been filed and you were, someone was seeking those discussions after the litigation had been filed. So those are two examples. I hope that helps.
So it's highly probable just based on, but the case hasn't actually been filed, but.
Yeah, that's right. And I think, this is the definitional language is what the Senate committee, the EEE committee, came up with. We're certainly happy to work with you all if there are tweaks to the definition to resolve, concerns. We can try to work that out.
Okay. I appreciate it.
Thank you.
Thank you, Madam Chair.
Thank you. I see Delegate Kaiser, followed by Taveras.
Thank you, Madam Chair. And on a related question to what Delegate Chisholm asked, I wanted to ask about who was deciding, not just the how was the decision being made, but who was making the decision. Thank you.
Sure, about reasonably anticipated litigation, Delegate? Yeah. So in the first instance, when the request comes in, as always, it would be the custodian of the records who is making the determination in the first instance about whether to assert the exemption or not. Then after that point, a requester, if they don't agree with the assertion of the exemption, would have all of the normally available remedies under the PIA for disagreeing with a custodian's decision. So they could go to the Ombudsman, the PI Compliance Board, or go to Circuit Court.
Delegate Taveras.
Thank you, Madam Chair. How does the currently amended bill, square with the concerns of the ACLU handout?
So I haven't seen their testimony on the amended bill, so I can't speak directly to that. I think the biggest change with this bill from the cross-filed House version that I was here before you all earlier in the session talking about is the fact that it, thank you, Dolly Hill, the fact that it applies only to records created for purposes of the litigation, which is much more tailored to part of the problem that we're trying to solve. The bill as it came in originally would have potentially applied to records created before the litigation that might be evidence in the litigation, but wasn't actually created because of the litigation. And I know that was a big concern of the opponents of the legislation, that the bill might reach that far. And this bill is more narrowly tailored to documents created for purposes of the litigation, which is a smaller and much more sensitive category of government discussions that we are talking about. And I'm happy to look at this testimony for a minute.
Yeah, they feel it's redundant, and it has a chilling effect on transparency, impairing investigations.
Sure. So on the redundancy point, there are, I think, at least three important ways that this is not redundant. The first I alluded to in speaking with Delegate Chisholm, existing protections like the attorney work product doctrine wouldn't necessarily apply to discussions within a government agency that don't involve the lawyers about the potential merits of threatened litigation or ongoing litigation. And the Open Meetings Act provision I mentioned in my testimony, one thing important to note about that is the Open Meetings Act has two separate exceptions allowing to close meetings, one for getting advice from your attorney about things including litigation, and one is the one I quoted is the body consulting with staff consultants or other individuals about the pending or potential litigation. So the General Assembly, I think, has already recognized that there are situations that don't involve lawyers but do involve discussions about pending or potential litigation where there are sensitive discussions that need to be able to happen without the public being able to see every detail about what those discussions involve. So that's one example. A second example is the work product doctrine, attorney-client privilege, deliberative process privilege, all of the existing law that might apply to some but not all of the records we're talking about. They are very technical legal doctrines that require very close parsing of sort of every line in a document, which then ends up making it much harder to deal with requests like this for documents created because of litigation, whereas we're asking for a sort of clearer, easy to administer rule that would apply in these types of situations. And then the third general category is there are sometimes discussions between the parties in litigation, like settlement communications, that again, under existing law, sometimes might be protected, but sometimes might not be protected. So this would allow for a clear rule that would, again, allow for the withholding, not require it. As with all discretionary exemptions, the custodian has to be able to show that disclosure would be contrary to the public interest in order to assert the exemption. So again, there's that extra step as well that the custodian has to go through.
Thank you, Madam Chair. My concern with this bill is the lack of transparency, especially in the times that we're living in right now, that limiting the public's access to information is problematic when we're dealing with so many different things at our state and federal government. And you already have all of the protections you need under attorney work product. If something is being prepared in anticipation of litigation, it's already something that can be excluded. And if it's settlement negotiations, that's excluded too. Our courts have been very clear in excluding those types of communications. So with that, I'm really not sure why this bill that would restrict public access to information is necessary at this time. Do you have any examples of where this has been a problem?
Yeah, so again, I come back to all of these doctrines, they do exist, but they are highly technical and difficult to apply in practice. And I can say that because part of my job in the past has been trying to go through these documents line by line and trying to apply these in practice. And it has, in fact, at times disrupted the operations of OAG and I'm sure other, government law firms that are in similar positions to try to go through these records that I think the General Assembly probably would have expected would not be subject to public access for the reasons you're talking about, Delegate Austin, because of these existing protections, but might nonetheless fall through the cracks with those existing protections or just make it much more difficult to respond to those requests. And so that's part of what we're asking for, is a clearer, easier to administer rule. I think we agree that a lot of the material in this category might already be protected under existing protections, but not all of it.
May I have a follow-up? I guess what I'm looking for is, do you have concrete examples where you've said, we're denying this request because it's attorney work product? And then you went through the process of someone saying, we disagree, it's not attorney work product, you need to hand it over, and it's worked its way through either the board or the court system where you've been ruled against, and they said, no. The board or the court has told you, no, it's not work product, hand over the documents.
Not yet, to my knowledge. There have been cases brought about these issues, but not yet, to my knowledge.
Okay, thank you, Madam Chair.
Thank you. So you can kind of sense the reluctance, right? From the
Sure.
committee as well. And I know I received a letter from a constituent, actually, Ms. Alicia Baines, regarding some of these issues as well. And one of the ones the issues that she makes is that this is redundant and unnecessary, as Delegate Tavera stated, and the lack of transparency as well. Before you leave, I'd like to, if you can hold a second for me, because I want to see if you can be available for a call.
Sure,
I
absolutely.
really would appreciate it. Are
Yeah,
there
of course.
You're welcome. Any calls? Any questions? Seeing none. All right, thank you for your patience as we ask all these questions.
Yeah, of course.
So this actually concludes the bill hearing on Senate Bill 555. Now we're going to go to Senate Bill 423. Senator Vital, anyone here for her? Okay.
Good afternoon. I'm Madeline Del Greco with the Maryland Board of Physicians. We would like to thank the sponsors and the stakeholders for working with us on this bill. Senate Bill 423 is in the same posture as the House crossfile, House Bill 776, and I'm happy to answer any questions.
Questions for her? Seeing none, thank you so much. This concludes the bill hearing on Senate Bill 423. Let's go back to Senate Bill 491. Anyone here for Senator Guile? Hi, how are you?
Good. Thank you, Madam Chair.
Good.
Madam Vice Chair, members of the committee. For the record, Spencer Dixon here to present SB 491 on behalf of Senator Guile. This bill is the cross-file of HB 699, sponsored by Delegate Allen. The two bills were both amended in nearly identical ways, but there is one difference I would like to point out. On page 2, line 15 of the Senate bill, the language reads, quote, "An individual is eligible for state benefits," unquote. And in the corresponding provision on the House bill, page 2, line 18, the language reads, quote, "A discharge should be upgraded." And just as a reminder, this is a bill that would expand the reasons for discharge upgrade for the purposes of state benefits to expand to TBI, post-traumatic stress disorder, and sexual assault in the military. And based on existing DVMF regulations, the effect of the language is actually the same. Because the existing infrastructure already exists, we're just adding those reasons to the existing framework. So Tripoli prefers their language. Senator Guile is agnostic, but DVMF is fine with Tripoli's language and would just ask that the Senate bill be in its current posture and a favorable report by the committee.
Are there any questions for Spencer? Okay. Spencer, thank you very much for being with us, okay?
Thank you, Madam Chair.
We appreciate it. This concludes the bill hearing on Senate Bill 491. Let's go back to Senator Kagan. Anyone here for Senator Kagan? Okay. Excuse me? Okay, would you like to do that, please? Oh, for which one? All right, so will you be so kind and speak on 127, please? Yes, from there is fine.
Okay, thank you, Madam Chair. Senate Bill 127 is the cross-file of House Bill 300. They differ in two distinct ways: the effective date, as well as the limit, the amount that will trigger a report. When it went through our committee, we put in a provision that any grants over $1 million would trigger a report. When I took the bill across the street on last week, we got a letter from the Department of Budget and Management expressing concerns with the $1 million, saying it would place an excessive burden on DBM staff resources. And they did not have a similar problem with the Senate version that would be triggered by $5 million. So what Senator Kagan and I would like to do is keep the effective date that's in HB 300 and change the report requirement to what is in currently in Senate Bill 127. So make it a $5 million report trigger and an emergency bill.
That will make it identical.
That would make it identical.
Okay. All right. Any questions? All right. All right. Thank you so much. This concludes the bill hearing on Senate Bill 127. And let's do Senate Bill 365. And that, Delegate Gazzoni, Department of Commerce, Nonprofit Organizations Navigator.
This is a bill that we did not move forward because of the fiscal note, which is $100K on the Senate side. It did pass through the Senate because, you know, their fiscal note level was a little higher than ours. I do think that there's been a couple of amendments on the Senate side, which I don't have off the top of my head right now. I know we were going to make it an emergency bill. And let me back up. This would create a position within the Department of Commerce that would be a navigator for nonprofits who are looking to apply for state grants. We have, I think the number is in the ballpark of 40,000 nonprofits here in the state. So particularly for smaller nonprofits, having somebody who really works grants for them is very, very difficult. They don't have the financial wherewithal to have a grants manager or somebody who's just working on grants. So this is particularly to help the smaller organizations. And with our current situation, many of those smaller organizations may be looking for state grants in a way that they were not before. So this is a navigator position that's going to help them get to the types of grants that are going to work for their organizations.
Thank you. And I saw the fiscal note, it's $80,400.
Okay, maybe it came down a little bit since I last looked.
And the other for FY 2027 is $69,000, and that's it. And there's actually an amendment that the Commerce supports Senate Bill 365, and they put the amendment in here, right, with the exceeding $250,000 amendment.
Yeah. For the CEO or executive directors of the nonprofit. Yes,
Okay.
Thanks for reminding me. I don't have my stuff in front of me. So.
We have. It says.
They want to remove that.
Oh, they want to, it says, Commerce supports Senate Bill 365 with an amendment that removes the requirement that the navigator cannot provide services to nonprofit organizations that pay an annual compensation exceeding $250,000 to any single salary employee. Commerce does not distinguish between for-profit companies based on their employee salaries when providing non-financial assistance, and therefore the department feels it should also not make such a distinction in relationship to nonprofits and their employee salary. Okay? So that's what they're saying. Because the Senate bill on page 2, line 29 to 31, has the amendment that says the navigator may not provide services to a nonprofit organization in the state that provides a total annual compensation exceeding $250,000 to any single salary employee. So Commerce wants that removed. Okay?
I have not talked with the senator about that, so I don't want to make a comment about it. I know that the 250K line was essentially so that particularly larger nonprofits aren't paying their executive director, like $1 million and taking state money to do that. But
so any other questions? All right, Vice Chair Collison.
Thank you, Madam Chair. Would it be possible to get like a an average salary of the CEOs, nonprofit CEOs? Just to have a sense of, how many are paying
Off the
more
top
than
of my head,
250?
because some of our things that you wouldn't necessarily think of as a nonprofit are nonprofit.
Yeah.
So my guess is nonprofits, executive director salary range is somewhere, but, can go anywhere from $40,000 a year to over $1 million, because some of our nonprofits are really big.
But if I may, I don't think it's necessary because it says Commerce does not distinguish between for-profit companies based on their single salary employee. And it says Commerce does not distinguish between for-profit company based on their employee salaries when providing non-financial assistance. Okay? So we can actually send this to subcommittee, please, okay? To work it out, all right? And we'll submit it. Oh, we were just finishing up your last bill. So if you can come over, we're discussing Senate Bill 365, and we are talking about the fiscal note. I said I'm going to submit it to appropriations, and they decide whether they'll fund it or not, but I'll submit it for approval once it goes through subcommittee. But the amendment, Commerce does not want the amendment that you placed on the bill regarding the $250,000. It's in the bill. It's actually second page, line 29 to 31. And I can give it to you. Can you give the senator
Second
this,
page.
please? Right here.
Oh, God. Yeah.
Oh, she got it?
Okay, yeah, I have it. Thank you.
Okay.
Madam Chair. Could I just say hi?
Yes.
I'm Senator Kagan, Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. The Senate is still in session, and we are debating part of our energy package, and at some point I just got up and I ran over here. So forgive the out of breath.
Kurt did an excellent job.
Of course
So
he
we're
did.
on 365.
So 365 is an enormous priority for the nonprofit sector. It proposes to add one person, one human being for the entire state of Maryland in the Department of Commerce. We have more than 20 ombudsmen or people with similar titles in our state government, but no one that helps our 41,000 plus nonprofit organizations that are under fire and under stress right now by this new administration, and they don't know where to go, and they don't have sufficient guidance. So a nonprofit navigator, one person, located in the Department of Commerce, and the fiscal note has this as just over the House's $75,000 limit. We see this as a really smart, hardworking, dedicated person, but kind of a mid-level person. This isn't a new department. This isn't a new office, not a new agency. It's one person who can answer basic questions like, is my group eligible for this grant? Or we haven't gotten reimbursed yet for our contract, and the Department of X isn't returning my phone calls. I don't know who to reach. And that one person is going to help solve a lot of problems. And right now, all the changes at the federal level, with grants being cut off, with contracts being canceled, with people losing their jobs, there's going to be more and more pressure put on our nonprofits in every community in this state. So there are going to be more people who are going to lose their homes and need housing assistance, more people who are going to need food from a local food pantry, more people who, through their stress, will use alcohol and drugs and need guidance, could find themselves battering their spouse, needing more child care services. And we need to keep our communities engaged with arts and humanities. All of these organizations are going to have fewer donors, more pressures, more demands. So again, Madam Chair, great colleagues on HGO, I implore you I understand that in the House, you guys are faced with a $75,000 cap. The fiscal note on this, if you take a quick look, it starts off, you already read that.
There, and I'm going to submit
Thank
it
you.
to appropriations.
Of course you did. So I have already talked to the Chair of Budget and Taxation about this in the Senate, and I appreciate your being willing, Chair of Appropriations. For a paltry amount, we can make a huge difference for organizations and every community around the state. I'm happy to take questions, and thank you for the opportunity to run over here and be with you.
Thank you. I know you're out of breath. I know how that is. So just take a minute. Any questions? If you could just be available for subcommittee, that would be great. Okay?
Happy to.
Thank you. Any questions for the good senator? All right. Seeing none, this concludes the bill hearing on Senate Bill 365.
Thank you,
And thank
Madam
you, Senator,
Chair.
for the courtesy. And then our lawyer will send you the link for you to be available for the subcommittee, okay?
Perfect, happy to.
Thank you.
And Maryland Nonprofits, Henry Bogdan, who I know you all know and respect as well, is also my partner on this. So feel free to reach out to him if we're jamming on the other side.
Thank you so much for your work and your leadership, and thank you for the mango.
Absolutely. Take care all.
Take care. Bye-bye. This actually concludes the bill hearings for today. At 1 o'clock, we're going to vote on some bills. 2 o'clock, and it is 1:49, so you have 10 minutes. I know I need 10 minutes for a minute. You can take us down.